that you could join us.
You could turn it more to you.
Thank you. We're just, yeah, wanted to welcome everybody, and we're very grateful that you're able to join us today. Just a couple of little logistics before I introduce Lisa Dodson. I always like to call her our volunteer extraordinaire because she is. But if you wouldn't mind, go ahead and mute your microphones. Of course, if you have questions, go ahead and unmute during the presentation. Or if you prefer to put your questions in the chat, we will be keeping an eye on that and asking the questions for you. But we find that you get the best sound quality if everybody stays muted, unless you're actually asking a question. So we appreciate that. Again, we welcome you today to our Triad series. Aging Together is all about connecting people to communities and to resources. Ultimately, we are all about improving quality of life as we age. And we do hope that you have taken advantage of all of the wonderful, programs and supports that we have in our community here and in Culpeper and in our 5-county region. I'm going to go ahead and turn it over to the person who has put together this Triad series. She's really done an extraordinary job. And that is Lisa Dodson, and she's our team leader for our Culpeper team. And I will go ahead and turn it over to Lisa to introduce today's speaker.
Well, thank you, Ellen. We're excited to be here and hope that you are too, to listen to Katherine Charapich share with us a roadmap to estate planning. And so Katherine is a lawyer based in Culpeper, Virginia, who focuses on estate planning, elder law matters, business formation, and contracts. Katherine obtained her Juris Doctor from Liberty University School of Law, where she also served as editor-in-chief of the Liberty Legal Journal. She earned a reputation for excellence in client service during her 20 years of prior business experience that she continues to build upon in her practice today. The office of the Estate Law Center is in a discreet location on Davis Street in historic Culpeper. In addition to practicing law in Culpeper, Katherine has made her home in downtown Culpeper, where she has raised her children, Breckenridge and Bryce. Welcome, Katherine, this morning. Thank you for being with us.
Thank you so very much. And thank you to those who are joining us. I thank Aging Together, the Harbor at Renaissance, and Virginia Triad for putting together this series. So I'm going to talk with you about estate planning today. Please, you are welcome to interrupt me at any time. I'm happy to answer questions. If it is a personal matter specific to estate planning or elder law, I'll turn the answer into a hypothetical because our conversation is not meant to establish an attorney-client relationship at this point. So I hope that at the end of this call, you will feel more educated than when you clicked start of the meeting. So that's my intent. There is no mystery in estate planning. It's truly about two matters: your assets, the use of those assets for your care, and your care. That's it. It's just about assets and care. So we'll break it down into those categories. What I'd like to do, though, just so to give a human side to estate planning, is to read a poem that I wrote. It was a gift meant for a surviving adult child. So when I share hypotheticals, I am certainly welcome to do that, as long as I don't share enough information with you that you could identify the clients. So these clients, an older adult couple, and they had owned a flower shop in the north prior to moving to Virginia. And when I did their estate planning, I actually went to a facility in Charlottesville for the signing of those documents. Often in elder law and estate planning, I get a call during the middle of the night that something has happened. And this did happen in this case, very personal, but I wanted to give a gift to the adult daughter. And I wrote this poem. So it's dedicated to this couple. And the husband passed before the wife. So you're going to hear some of this, and then we'll get directly into the estate planning. So here we go. To put pen to paper, to capture the scene, to bring life alive to those slipping away, to those who have not known such change. The bride's picture that's dog-eared and weathered, fading along with each day in assistance. The memory that flutters just on the edges, grasp it, catch it. Yes, I think it was mine. You promised, I expected, now we are here. The days lapsed, milestones reached. What now is in store? The call came late in the night, early once morn. Each echoes pain, seeks answers, none there. Communities thrive, calendars are full, meetings occurred, festivities, lights, events beyond this. But what about this? This community that once was, paved the road, sacrificed, now is here, now is housed, accused of asking a lot. What? To be heard, to be remembered, or even respected. Have I not taught you a thing or two? Movement now, appointment to appointment, paperwork to paperwork, medicine to medicine. The network has thinned, the support is paid. The house that was is now a room with a chair. The chair is a memory thread. A link I hope is there, a memory before the fall, a building block. Catch a glimpse of the child, of the flowers in our business expression, the city, the you and the me. We transitioned and coped. Event one was the worst. Separation exacted from my lifelong love. How are you doing? Question posed to a temperance frayed. The truth spoke humor, just ready to get out of here. Have I failed you? No longer able to navigate the stair flight? Visits last past daily PT or the community lunch. But a visit it is. I am here. Do you recognize me? Your dance partner, your circle, your balance, caretaker too. The call came, first call out of the blue. Balance is no longer two. Will she know? Perhaps in a communication changed. Now documents will dominate. He took care, though they are not warm, not even a whisper. Perhaps soon a beckoning will occur, and all will be as it should. Bouquets in heaven, a flower shop there. Thank you for letting me share that. Very special couple who help take care of each other. And when one predeceased the other, the one who survived, we're not sure she even knew what had happened, what had occurred. All right, so let's talk about estate planning. Again, if you have questions, please place those in the chat or please unmute and go ahead and ask. So when we think about estates, we think about the documents that can help control the care for us and the use of our assets for our care and the distribution of our assets seamlessly when we pass. So when we talk about the documents that are afforded us in Virginia, they are trust, there are wills, there are powers of attorney and advanced medical directives. Now, there are often ways to plan that cost less than others. So when somebody meets with me, I ask that they bring the following documents with them if they have them readily available. So any deeds to interests that they own in real estate, so dirt with improvement, their last statements for their cash savings and wealth management. If they own any interest in businesses, I ask them to bring the originating documents, the controlling documents to those interests, their retirement plans plans, their life insurance policies, their long-term care policies. Because can I draft a last will and testament in the dark? Sure, I can, but will I do that? I won't. That's not best practices, because how you have titled your assets, as well as if you have named beneficiaries on those assets, may trump your last will and testament. So it's important that when we conduct estate planning, that it's a comprehensive picture. So let's start with trust. There are irrevocable trust and revocable trust. So irrevocable trust are the Medicaid planning, the asset protection planning. We're going to set those aside. That's for a session unto themselves. So we're going to talk about revocable trust. I am a big advocate of revocable trust as long as the benefits outweigh the expense. I don't want a client spending money on something that they don't need. I review a lot of estates. Clients will come in with their thick 3-ring binders, and often they will include a revocable trust. I will ask them 2 questions. Why did you feel that you needed a revocable trust? And they often can't answer that. And also, what did they fund into that revocable trust? So if all that has been funded into that revocable trust is that magic $10 in order to open the trust, it's very expensive. They spent a lot of money and time, and that trust wasn't worth anything. So we'll talk about that in a minute. So here are the possible considerations for having a revocable trust. If you have real estate, if you own interest in real estate outside of the Commonwealth of Virginia, that's a reason, because real estate is probated in the jurisdiction in which it's located. So if you own property in the Commonwealth of Virginia and property in a foreign jurisdiction, say North Carolina, and those properties are not deeded into a trust, you may have created a probatable estate in Virginia and an ancillary probate estate in North Carolina, not a gift to leave to the person who is trying to settle your estate. Another reason for having a revocable trust in place, if you want to control from the grave. So what I mean by that, now, respectfully, $1 is as important to somebody as $100,000 is to another person. So when I'm using these figures, it's just as an example. So if I want to leave $100,000 to my daughter, but I'm not sure about the health of her marriage, and my daughter's not married, this is just an example, I may want, upon my death, to leave that $100,000 in a spendthrift trust so that the assets in that trust can be used for the benefit of my daughter, for her health, her education, her welfare, her medical needs, her quality of life. However, not at her discretion. So at the discretion of a trustee of that trust, so that if she does get divorced, then the court can't reach in that property settlement agreement and take part of what I've left to my daughter, because it's in a spendthrift trust, not at the assets not to be used at her discretion, okay, at the discretion of the trustee. Or perhaps I want to leave $100,000 to my daughter, but I'm unsure of her. She may have some spending issues. She may not be able to manage her assets well. She may have creditors in the wings, so that if I leave an outright distribution of $100,000 at my death to my daughter, then she may buy that fancy car and not be able to afford the gas. Or she may have the creditors that as soon as I distribute, or that money, excuse me, I'm dead, that money is distributed to my daughter, the creditors can come in and claim the money, and then she receives no benefit from that. So another reason to have a revocable trust, it is private unless the trust is contested. So a will, once a will is submitted for probate, that's public information. A trust, if I want to leave an asset to an individual and I don't want the public to know about that, the trust is not, the public can't see into that trust, okay? Another reason would be to avoid probate. Now, avoiding probate's a good thing. There may be less expensive avenues to avoid probate. However, and we'll get to what probate looks like, but it is a reason to avoid probate. It's also if you think that you have beneficiaries who may be greedy. So say you leave 50% to one child, 50% to another. However, one child, you're pretty sure that that child is going to contest your trust. I took care of mom and dad at the end of their life, so I deserve 75%. So upon your death, they can test your trust. Now, of course, trust can be contested. However, a trust contest is less likely to be won than a will contest. So a will is valid at the time of your death, or we hope it's valid. We hope it's well written in a manner that's acceptable to the clerk of the circuit court. But that will is signed during your signing ceremony, and then that will is stored in your safe, your gun safe, or a safe deposit box at the bank. A trust is effective the day that you sign. So if that trust is put into effect and the terms of that trust, say 20 years goes by before you pass, a judge is more likely to uphold that trust, because if you, the trustor, had wanted to change the terms over the last 20 years, you would have. So again, the judge is more likely to uphold the terms of that trust if there is a trust contest. So even if you have a revocable trust, you still need a will with pour over language. So what that means is we fund all the fundable assets that we can into your trust. So that means your real estate gets deeded into your trust. If you own interest in a business, we assign those interests into the trust. Your cash savings and wealth management that's fundable into the trust, are funded into the trust. Now, what I mean by that is 401ks, IRAs, and annuities should not be funded into a trust, cannot be funded into a trust. Well, annuities sometimes, but IRAs and 401ks can't be funded into a trust during life. Okay, so we fund all your fundable assets into the trust, and then we have this pour over language that we use as a safety net. So if you inherit an asset on a Monday or purchase an asset on a Monday, and God takes you on Tuesday, so you didn't have time to fund that asset into the trust, what do we do with that? We still want that asset to pass per the terms of your trust. So we pull that asset in through probate, and then that asset pours over using the pour over language into your trust to be administered and distributed per the terms of your trust. All right, so what if you don't need a trust? And what if we can, there's really no such thing as a simple will, but what if we can distribute your assets through a will? All right, so let's talk about that. A last will and testament, should you have one? Absolutely. And when I write a last will and testament, I write a will, your will, as if all of your assets pass through your will. What I mean by that, your real estate, so your real property, your personal property, both tangible property and intangible property. So tangible property, your cars, your boats, your planes, your household furnishings, your jewelry, okay? The things that you can physically touch, and your intangible personal property, your cash savings and wealth management. So let's go back to this. So if we are writing your will as if everything passes through it, which you should, use it as a safety net. Then let's look at your assets. So still have a will. And then let's look at your assets and design your estate so that nothing passes through that will. Again, using it as a safety net. But then if we can avoid probate, that's ideal. How do we do that? All right, so we look at your deeds. Now this is as if you own property, real estate in Virginia. So let's start with the real estate. So in July of 2013, the General Assembly made available a transfer on death deed. It's a beautiful deed. All right, so you have your deed. A little bit of a real estate lesson here. So take a look at your deed, which states how you own that real estate. All right, so you could own, a married couple could own your real estate as tenants by the entirety with rights of survivorship. That is the most ideal way for a married couple to own their real estate. So you'll understand the survivorship language because you may see that as joint tenants with rights of survivorship in your bank accounts. So afforded a married couple, and only a married couple in Virginia, is the tenants by the entirety nature. That would mean that if, so for a married couple, if I created a debt that went unpaid, but it was a debt created by me, just me, the creditor could not lien the property because my spouse and I did not create that debt jointly. So it's a protection, okay? However, the survivorship language, on the first to pass, my spouse, so if I die first, my spouse would take the interest and own the property 100% fee simple by operation of law. Best practice would be to put my will to record, so it's probate without qualification, just putting the public on notice that my spouse now owns the property 100% fee simple. Okay, but it's on the last to pass. How do we get that property to the beneficiaries? By avoiding probate, or yes, by avoiding probate. Okay, so we're going to address that in 1 second. So tenants by the entirety with rights of survivorship. The next way to own interest in property is joint tenants with rights of survivorship, which could be between a married couple, or it could be my neighbor and myself, or 10 people. So it's the same concept that on the first to pass by operation of law, the survivors absorb the decedent's interest and they now are the owners. It's on the last to pass. How do we pass that property and avoid probate? You could also own property interest, tenants in common. We see that a lot in investments. So if I own my property with my neighbor, tenants in common, we could own it 50-50, 30-70, 60-40. What you want to be careful of, there's no survivorship language. So if I own 30% and my neighbor owns 70, when I die, my 30% is controlled this way. Either I have deeded my 30% into my trust, or it's going to pass via my will, or if I don't have a trust or will, it passes intestate. It passes by the laws of descent and distribution set forth in the Code of Virginia. So there's a default, okay? So if I don't plan, the code, the General Assembly has already planned how those assets will descend, and we'll get into that in just a second. So my point for real estate, if you want to avoid probate, this beautiful deed called a transfer on death deed can get recorded. It's the one deed in Virginia that has to be recorded prior to the decedent passing. All right, so here's your deed. It's recorded in the land records, let's say in Culpeper County, okay? So I own my property, but I want to avoid probate. So I record a transfer on death deed in the land records. It doesn't take the place of my first recorded deed. It's considered a deed in waiting that only comes out if I own any interest in that property upon my death. So I can sell my property, I can encumber my property, but if I own any interest in this property at the time of my death, here comes this deed in waiting, this transfer and death deed out of waiting. It passes the interest in my property to my beneficiaries, avoiding probate. That's beautiful, right? It was for the cost of a deed. That's it. Okay, so let's talk about tangible personal property. If your assets in the aggregate, so your cars, your boats, your planes, your household furnishings, your jewelry, in the aggregate exceed $50,000, you will have created an automatic probate estate upon your passing, unless you have funded those assets into a trust and passed them that way upon your death, or if you own those assets jointly with rights of survivorship, Or if you have a car that you don't have a lien on, there is paperwork at the DMV that you can actually name a beneficiary on your death. So that's an inexpensive approach to managing your tangible personal property, the assets that you can touch upon your passing. So what about intangible personal property, your cash, your savings, and wealth management? How can you avoid probate if you don't want to spend money on a trust? So whether you have solo accounts, cash, savings, and wealth management, or you have joint accounts with rights of survivorship, please, on each of those accounts today, before the close of business, touch base with your providers, your banks, your wealth management companies to make sure that you have named both primary beneficiaries and contingent beneficiaries. That's a way of avoiding probate without any cost. It's beautiful, okay? All right, so please, you should have a will in place, but again, take a look at your entire estate and make sure that there's nothing lurking that you have not touched. So let's move from, we've already glanced at trust, we've talked about wills, and again, we've done this at a broad stroke, and I think I'm going to come back to wills in just a minute. But let's address powers of attorney. A power of attorney is absolutely the most important document that you can have, because what's more important than your assets is the care for you while you're on this earth. Please, please, if there is one document that you invest your time and resources in putting in place, a power of attorney. I'll forewarn you, mine are 16 pages in length. I leave nothing to chance. This is risk management. Please, while you have the capacity to make decisions for your care, the use of your assets for your care, what parameters, what boundaries are important to you, please put these documents in place. I can't emphasize that enough. So a power of attorney. Think of a power of attorney as having two main pillars. So one is, and you'll recognize this because the first one is what we always think about, the use of your assets, helping you with your assets, helping you pay your bills. The second column is helping you maintain your quality of life. And then there's this broad stroke umbrella that's part of this power of attorney: legal matters, contractual matters, communications, interacting with the government. All of that should be part of your power of attorney. Now, we know of limited powers of attorney. If you're purchasing real estate and you can't be at the settlement table, you may give a limited power of attorney to your attorney to sign your name. We're not talking about that type of power of attorney here. We're talking about a broad stroke power of attorney, helping you maintain your quality of life, use of your assets for your care, and then powers of attorney go away at death, or you can revoke them at any time you have capacity. Now, powers of attorney can go into effect the day you sign, or you can make them effective upon incapacitation. I encourage my clients, please make your power of attorney effective the day that you sign, because if you don't, and you're just traveling, but you need a legal document signed or a bill paid, your agent under your power of attorney has no authority. You're just traveling. You're not incapacitated. I encourage clients to name as many agents as they can trust. So that would mean a primary agent. And then in the event that primary agent is no longer able to serve, a successor agent, then an agent after that. So if you do not have a power of attorney in place, or you have named, say, 3 agents, and none of those agents are able to act as your agent under your power of attorney. It's as if you don't have a power of attorney, and you have, in fact, teed this up so that somebody has to petition the court for guardianship of your person, conservatorship of your estate. You have lost control, because if you don't have a power of attorney in place and you are incapacitated or can no longer give agency, it's a guardianship petition. Here's what that looks like. Please do not ever get to this. I'm going to put this in human terms. This should never happen. All right. Adult children, again, in a hypothetical, not giving enough information, you can identify these individuals. Adult children came to me. Their parent had not put a power of attorney in place and no longer had the capacity to do so. However, the parent didn't realize she had a cognitive disorder. And sometimes with cognitive disorders, there are conspiracy theories that run with those. So when her children petitioned the court for guardianship and conservatorship, she didn't realize that they were doing this on her behalf, in her best interest. She literally was living in a mansion that was not inhabitable anymore. She couldn't take care of herself. She wasn't taking her medication. She didn't have the wherewithal to maintain her quality of life. However, here we were. I'll never forget this day. It was in a day in December, and it was not in this jurisdiction. It was in Virginia, but all the courts were closed. However, the court opened just for this matter. It was contested. So here's this dear lady on one side of the court. On the other side were her children and family, of course, the guardian ad litem. And I had photos and testimony, and I was trying to maintain this court in a way, the setting in the court in a way that maintained this individual's dignity, because you never want to end up in this position. So she was there in her Pendleton tweed and slumped down in her chair like this with her bags around her. And there was no way that I could present these photos. I had to show her, and she wasn't represented in a way to maintain her dignity. And there's never a win in this situation, just because of even her behavior in the court, where she was calling the judge names. And the guardian ad litem did a fantastic job giving his testimony. It was just very, very sad. Yes, guardianship was awarded, but if we could have avoided that, if she had put a power of attorney in place while she had the capacity to do so, we may have never ended up there. So please put the boundaries, the parameters in place that work for you. Name the agents that are acceptable to you while you have the capacity to do so. You don't ever want to end up in a guardianship conservatorship petition if it can be avoided. So let's move to advanced medical directives. There is a default in the code that allows a hospital to turn to your family members, your friends, or a person who expresses an interest in your case. Now, I'm uncomfortable with that because I want to control who makes decisions for me, and I want to make sure they make those decisions based on what I have memorialized, the wishes for my care, for my medical care, if I'm not able to make those decisions for myself, as well as my end of life. So an advanced medical directive affords that. It allows you to memorialize the wishes for your medical care, your end of life, if you're not able to give the direction yourself, okay? As well as who you trust to make those decisions. So the agency authority under an advanced medical directive feels different than the agency authority under a power of attorney. So if you say you name your adult child as your primary agent, and then you name a friend as the backup agent, your adult child can waive agency, doesn't have to take that role on, or if that adult child is no longer to maintain that role, he or she can step down. If you have the capacity, you can remove that agent, or a court can remove that agent. Okay, so if you no longer have capacity to remove the agent, or they're unwilling to step down and they are self-dealing or abusing that role and refuse to step down, then your next in line, that agent who's next in line, could petition the court to deem you a ward of the state. So this is a guardianship petition, but it's the only way to remove that agent if they're unwilling to step down and you no longer have the capacity to revoke your agent or to revoke your power of attorney. So it would cause for a guardianship and a conservatorship petition. Okay, so in an advanced medical directive, if the hospital cannot reach the first agent, the way my advanced medical directives are written, that hospital or that physician, if they can't reasonably reach that first agent, they can go to the next agent and the next agent, because it's a medical or end of life. So time is of the essence. It's important so that a decision for your medical or end of life care can be affected. Please put those documents in place. So let's go back to last wills and testaments. There's no mystery in a last will and testament. I had talked about how do we avoid probate. So what is probate? There is a probatable process if you have not funded assets into a trust, or if there's not survivorship or beneficiaries named for cash savings and wealth management accounts. Okay, so what is probate? A probatable process exists if you have a last will and testament, or if you do not have a last will and testament, it's an intestate estate, but it's still a probatable process. And that means that if there's a will, your executor or executrix takes that will and submits it to the clerk of the circuit court, qualifies as the fiduciary, the executor or executrix. If there is no last will and testament, but there are probatable assets, then say it's me and I'm looking at somebody else's estate and I want to help settle that, then as the estate administrator, as a person who would like to take on that role, I qualify as the estate administrator. So here is a mistake that a lot of individuals make. So if I'm named as the executrix under somebody's last will and testament, it may make me feel good. And when that person passes, I run to the courthouse and I submit that will for probate and I qualify as the executrix without taking a look at the asset and debt column. So please do not ever run to the courthouse without first analyzing whether the debts outweigh the assets. Because if the debts outweigh the assets and I run to the courthouse and I qualify, guess what I have done? I have just now pivoted myself to settle this estate, and the chances are that the creditors will be paid pennies on the dollar and the beneficiaries named in that last will and testament will take nothing. Why not let the creditors fend for themselves? Okay, so please do that analysis before you run to the courthouse and qualify as an executor or executrix under a last will and testament, or as an estate administrator if the estate is intestate where there was no last will and testament. So if you are considering a trust, a last will and testament, a power of attorney, or an advanced medical directive, and you're concerned as, say, a parent, and you have 2 or 3 children, and you're concerned about hurting a child's feelings, especially if it's a last will and testament. I often have this comment made to me by clients when they are putting forth or telling me what's important for their last will and testament. They're concerned about hurting somebody's feelings, and I tell them, naming somebody as an executor or executrix, it's not a role of honor. Please tell your child to get over it. It is truly a role that can dominate somebody's life. Also, they're concerned about naming co-agents or co-executors. I'm not a fan of co-agents or co-executors. If a client wants that, of course, I'll write that in for my client. But we all have different work ethics. So where there wasn't any discord, you may have created discord between adult children. In my book, there should always be a king and successor. So if that person is unable to continue or to step up into that role, then the next successor, but one and then others. So a probatable process, somebody qualifies in that fiduciary role, let's say as the executor or executrix, they have 4 months to actually submit, 4 months from the date of qualification to submit an inventory. That means from the date of qualification, they take control of all the assets that were not controlled outside of probate. They take control of those, and that means establishing, well, they get an EIN number for the estate, they establish an account in the name of the estate, take control of these assets, and then they start to, are there debts? Or we would have already done this analysis. We know what some of the debts, we may not know what all of the debts are, and you start to possibly pay some of those debtors. You never want to make the estate insolvent, and the code sets forth the order of payment for debtors. So if you've taken on that role of an executor or executrix, and say you pay, there's an order of, like, let's say 1 through 10, and 10 being credit card debts. If you pay the credit card debts before paying the cost of the administration of the estate, and you make the estate insolvent, you can be held personally liable for paying out of order and making that estate insolvent. So please be very careful when you take that fiduciary role on. All right. So 4 months for filing the inventory, and there's a commissioner of accounts to whom that inventory is filed, and that commissioner of accounts is the officer on behalf of the court that handles estate and probate matters. We fortunately in this area in Culpeper and Madison and Rappahannock and Fauquier, we have excellent commissioner of accounts. We are very, very fortunate. Anyhow, okay. And then after the inventory, 16 months from the date of qualification, the fiduciary, the executor or executrix, has 16 months to file a 12-month snapshot of, it's the first accounting, a 12-month snapshot from the date of death for the following 12 months of what occurred in that decedent's estate. So if you could have avoided probate because that estate may not be settled within that first accounting, you may have multiple accountings, meaning a first accounting, a second accounting, you may get to a third accounting, a third year before you're able to settle that estate. That's not ideal. So in a last will and testament, some of the considerations when you're thinking about your will, who you want your executor to be or executrix, what assets, if any, you want to pass through your will, as well as, do you want a specific bequest? So say, for example, you want to leave a heirloom pocket watch or an heirloom strand of pearls to a neighbor because they've done something nice for you. And you didn't know that, you wanted to leave that specific bequest at the time of your writing. If there is language embedded in your will that allows for we call it a living list, then you could take a piece of paper. This is after you've executed your will. You could take a piece of paper and say, on one side of that paper, I want my heirloom strand of pearls to go to Jane, my neighbor, because she's done something nice for me, and I sign it at the bottom. I can add to that list. I can subtract from that list. And in the language that I write, as long as that list is found within 30 days of the qualification of my executor or executrix, it will be given effect. Now, if that strand of pearls is not part of my estate at the time that I pass, No cash nor other item will be substituted for that. It's the best of all worlds because we don't know when we sign that will, we don't know what assets that we may have in 10 years or somebody who may have done something nice for us and we want to leave something in a token, upon our passing. So, all right, I'd like to talk with you since we're talking about wills. There's this case, you may have heard about it. It's Whedon v. Whedon. It went to the Supreme Court of Virginia in 2012. Dorothy Rose had 5 children. Their names, Larry, Perry, Billy, Gloria, and Mary Ann. This case was all about testamentary capacity and undue influence. When you sign a will, you need to be over the age of 18, of sound and disposing mind and memory. You need to sign that will in front of 2 witnesses, and the witnesses need to sign in front of you. Preferably, you also sign a self-proving affidavit, because if you don't sign that self-proving affidavit at the time that you sign that will, and the will needs to be notarized, if you don't sign that self-proving affidavit at the time of signing that will, the clerk of the circuit court has to track down the witnesses in order to prove that in fact they were there and witnessed that you signed the will. So sign a self-proving affidavit at the same time that you sign a will. Okay, so back to Dorothy Rose. She had 5 children. In 2000, Dorothy became sick and her daughter, Mary Ann, helped to take care of her. In 2003, Dorothy Ann contacted Mr. Lowe, who's an attorney in Virginia, and had Mr. Lowe write a last will and testament, a power of attorney, and an advance medical directive for her. And in that 2000 will, that will dated 2003, Dorothy Rose made a monetary gift to her church. She gave burial plots to Billy, Perry, Larry, and Gloria. So she left out Mary Ann on the burial plots. However, Dorothy Rose left her real property to Mary Ann, Billy, and Larry. All right. So as Dorothy Rose became more ill, as her sickness increased, Mary Ann actually took on more responsibilities, and in fact, for caring for her mother. And Dorothy Rose actually started to need dialysis treatments. And so Mary Ann quit her job and devoted her time to taking care of her mother, Dorothy Rose, full time. So at this point, Dorothy Rose had her 2003 will in place. When that will was written, Mr. Lowe had drafted that, that's the attorney, and Ms. Garnett, Mr. Lowe's assistant, had actually been in that room and had helped take some notes. Both Mr. Lowe and Ms. Garnett recognized and made comments to the court following this that Dorothy Rose was a woman of few words, but knew exactly what she wanted. So fast forward, that was 2003. And then Mary Ann remember I had stated Mary Ann quit her job in 2006 to help take care of her mom full time. Christmas Eve, 2006. Now there must have been some falling out between Dorothy Rose and her daughter Gloria, because Gloria was not permitted to come to Dorothy Rose's house for Christmas Eve dinner. That made Billy angry, and he had some heated words with his mother, Dorothy Rose. Well, Dorothy Rose, being the mom, said, I don't deserve to be treated like that. And in May of 2007, called Mr. Lowe and said, I want a new will. Well, you can guess, and I wish we had the back and forth and we were in person. You can guess what this new will stated. So we are going to call this will the 2007 will, all right? And in this will, there was still the monetary gift to the church. However, the real property was now left to Mary Ann, Perry, and Larry, and Billy was nowhere to be found in that new last will and testament. In fact, he was also removed from Dorothy Rose's advance medical directive. Now, fast forward to May of 2008, Dorothy Rose was admitted to UVA's medical center. She was prescribed some painkillers, and she was confused at times. And Dorothy Rose was told by her doctors that she was going to need surgery. However, she needed to stabilize before surgery could occur. So that was in May of 2008. On June 19th in 2008, Dorothy Rose instructed Mary Ann to call Mr. Lowe's office. She wanted a new will. Well, Mr. Lowe was out of the office, and Mary Ann reached Ms. Garnett. So upon Mr. Lowe's instruction, Ms. Garnett was told to call Dorothy Rose at the hospital. So over the phone, Ms. Garnett made notes on Dorothy Rose's last will and testament of the changes that Dorothy Rose wanted. And Ms. Garnett testified to the fact that she recognized Dorothy Rose's voice over the phone, and that, again, Dorothy Rose was a few words, but knew exactly what she wanted. So when Mr. Lowe's got back to the office, he made changes to the will, and Ms. Garnett faxed that new will to, so Mr. Lowe's drafted a new will. Ms. Garnett faxed that new will to the hospital. So in the hospital room, there was Mary Ann was present, a notary was present, and 2 witnesses, not Mr. Lowe and not Ms. Garnett. Dorothy Rose signed the will in front of the notary and 2 witnesses. So she actually, she signed that will, and that was in June, and she also passed away in June. You can guess what, and it was within a week time frame, what that new will said. All assets to Mary Ann. Well, guess who contested? The other 4 children. The other 4 children actually won in the trial court. So this was appealed up to the Virginia Supreme Court, and the Virginia Supreme Court ruled on behalf of Mary Ann and said the fact that the attorney was not in the office, or was not in the room when Dorothy Rose signed, because the witnesses said they would never have witnessed if Dorothy Rose had not had testamentary capacity. The fact that Mr. Lowe was not there was fine, and actually upheld that Dorothy Rose had capacity to sign her will. So here's what the Supreme Court of Virginia was looking for when they made that decision of whether or not testamentary capacity was present. Was Dorothy Rose capable of recollecting her property? Did she know the natural objects of her bounty, to whom she wanted to receive the bounty? In this case, it was Mary Ann. Did she know the business about which she was engaged? And the Supreme Court of Virginia felt that Dorothy Rose knew she was signing her last will and testament. And did she know how she wished her property to be disposed of? And they deemed it yes. They also deemed that there was no undue influence. The fact that the other 4 children said, "We visit our mom, we took care of her," the Supreme Court of Virginia did not believe them. And they said the fact that Mary Ann was in that room and was the caretaker in this instance, there was no undue influence, though it's really not it's not best practice to have a beneficiary in the room when the last will and testament is signed, and you'll find other attorneys agree to that. So in this case, though, that was upheld. I do see that we have a few moments for questions. I am happy to answer any questions. I hope this was useful to you, and I thank you for your time. Lisa, Ellen, how would you like to handle answering of questions? Are there any out there?
Well, first of all, thank you so much. Oh my gosh, I was like frantically scribbling, taking notes and everything, and I'm sure other people were as well. So please, yes, go ahead, and if you have a question, just unmute yourself and please ask or put it in the chat. And Lisa, I don't know if you have anything that you wanted to add or say.
Well, I just wanted to thank Katherine for being here today. It was just a wonderful presentation. Certainly, I know it's very helpful to all of us that are in attendance today. It's really very difficult. I know I deal with a lot of families, and many times they've just not properly prepared for, what is honestly the inevitable, and things need to be put in place so that you can make sure that the appropriate measures and things that you want to have happen do so. And so I just thank you for coming. It was a great presentation. Thank you.
You're so very welcome. I would encourage, again, the more educated the public, the better.
Yes.
If you go to my website, estatelawcenter.com, and click on articles, I've written some articles that may be very useful to the viewers. That doesn't cost anything, right? So again, maybe it'll be helpful to those of you viewing.
I mean, I just had one clarifying early on when you were talking about the deed and of the house. So I think and I know it was like so much information. I was trying to take it all in, but I think that you were so if a couple owns their house together and one of them passes, you still have to make sure that you have documentation that the deed would go to the surviving partner?
Okay, that's a great question. Thank you, Ellen. So often when I'm reviewing estates and I ask a client, because I ask them to bring their deeds so that we don't overlook anything, please do not ever make this assumption. I will ask them, do you own your property as tenants by the entirety with rights of survivorship? It's the survivorship language that is key, or joint tenants with rights of survivorship. And they say, oh, we know we do because it says husband and wife on our deed. I said, please, it says husband and wife on your deed so that when there is a chain of title search, it's actually saying there may be somebody else who has a claim on this deed. It's not the fact that it states husband and wife. It's whether or not survivorship language is included in that on that deed. So that's important. So please check your deeds. On the first to pass, it's best practice to put the public on notice. So if there is a will that the decedent has, put that will to record. Probate without qualification if there are no other assets. And now there's an article. There are a couple articles on my under articles on my website that address that matter. So it'll take you right through the process.
I really appreciate that because I've got that 3-ring binder downstairs. I'm like, I'm going to go run and check everything. And I expect a lot of people are going to do that after listening to you today.
Are there other questions?
I'm looking in the chat. Well, there was a comment that the poem that you read was very beautiful. So thank you for sharing that.
Thank you for that. That was really hard. I actually got the call in the middle of the night that from the husband when he was still living that the wife had fallen. It was, anyhow, yeah, it was hard to see this.
Catherine, I have a question. This is Wayne Biggs.
Hi, Mr. Biggs.
I have a question. Hi there. About executors. I guess traditionally I've always thought of an executor as being a family member, but for some people they don't have families, or for some people it may be better for whatever reason not to have a family member. So who would that normally be if it's not a family member?
So I encourage clients, if you don't have a family member, perhaps a friend, a church member. And the beauty of this is that the individual who takes on the role as an executor, it could also be an entity, a person at a bank. The person who takes that role on has to perform per the terms of your last will and testament. So there are strict procedures set forth in the code of how probate needs to be administered. And so they can't deviate from that. There's a lot of oversight. So take some comfort in that. Does that answer your question? I hope.
No, it does. It's occurred to me more and more that this is a very important responsibility and one that can be very, very time consuming. And so, that was a question that I had. So thank you.
You're welcome. It really can, taking on that role can be all consuming. There's a compensation that is written that we respect in this area. We actually go based on what Fairfax County has set forth in their schedule. The executor gets a one-time payment. It's 5% of the first $400,000 of the probatable estate, and then that percentage decreases as the value increases above that 500,000, the first $400,000. So it's 5% of the first 400,000, and then it's a sliding scale for payment. Again, it can be a full-time job. So if we can avoid it, fantastic. And there are less expensive ways than others to avoid it.
Catherine, a few more questions have popped up
Yes.
here in the chat. One is if the right of survivorship is not on that deed, how do you change it?
I won't know until I look at the deed. Okay. You want to be very careful. If it's between spouses, we would use a deed of gift. So if I wanted to gift to my spouse and make the ownership tenants by the entirety with rights of survivorship, I would use a deed of gift. Okay. And you can gift between spouses. There's no grantor or grantee tax on that. Please be very careful of what I'm going to say next. I often have a lot of clients who come into my office saying, I want to put my adult child on as a joint owner on my deed, on my property. Please don't do that. Here's why. That may make it easy upon your passing. So if I want to name my daughter as a joint owner with rights of survivorship because it's going to make it easy, well, guess what? If she gets divorced or if there's a creditor in the wings, her interest could be tapped, and the equity that I counted on to help with my medical expenses is no longer part of that property. It's not accessible because it's no longer in existence. There are other ways to get that property to that adult child upon your death. Now, right now, we can take advantage of the stepped-up basis for taxes. So the adult child would take the basis upon my death versus taking the basis on my purchase. If I gift to my daughter, she takes the basis of my purchase versus the basis on my death. Now, right now, we're not sure if the stepped-up basis is going to be going away. There's a lot of change that may be going on right now with this that will affect some of our estate planning. So
you would have to, basically you would have to go back to your attorney or whomever did, like if you noticed that survivorship wasn't on that deed, you would basically have to go back to your attorney to figure out how you would address that.
If there is somebody that you want to jointly own your property interest with, then yes.
I hope that answers Kay's question. There's another question here, and if not, please respond in the chat. And there's another question here from John. Is there a checklist or training for an executor? That's a good question.
So yes, there are checklists. Some of my articles address that. If you'll look, please, at those articles. The very first thing, again, is an analysis of the debts and assets before you even take that role on. And the commissioners of accounts are very good at giving, as well as the court, there's a packet of information that's presented.
Great. Well, I know we've gone just a little bit over, but Lisa, and over to you.
Well, we just want to thank everyone for coming today, and certainly this has been recorded, so Aging Together will have this up on the website. If you were taking notes like Ellen, and maybe as you go back you're having a hard time reading them, because I took notes and I'm having a hard time reading mine now, go back and take a second glance at Catherine and her presentation. And if you know others that are struggling or in this position, they may find themselves in a position like this, and with regard regard to being the executor, or maybe they don't have the documents in place that they need, have them go back as well. Please direct them to the Aging Together site. And Katherine is always available to speak with folks. And certainly we've put up her website, and so you can get in touch with her there. Actually send an email, I believe, to her through the system that you have in place there as well. So we just want to thank you for coming, Katherine, today, and wish everyone well for the balance of the day, and join us for our next seminar, which is going to be in 2 weeks. And I think Mike Grant is our next speaker, and he's going to talk a little bit about some of the different things that he deals with. And so I think he's going to talk about some of the upcoming holidays and some of the different scams and frauds and things like that 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 sometimes happen during that time of the year. So join us for that as well. And all that information is on the Aging Together website.
Thanks, everybody.
Thank you
Thanks,
all.
Lisa. Thank you,
Thank you.
Catherine.
Thank you.
Awesome.
Thank you. Appreciate it.